All right, so now the second part of our seminar, we're going to move from talking about problems, which are depressing, to solutions. So a properly planned estate can be handled in one of two basic ways. One is with a living trust, and one is with a last will and testament. And we're going to talk about how the issues and problems that we saw in the first part of the presentation can be dealt with by either technique. The solution can come in either way. Most people are very familiar with the concept of a will, and that doesn't need much explanation, but a living trust is not very familiar to some people. So we're going to spend a little bit of time talking about what is a living trust. And a living trust is like any trust. There's a lot of similarities. There are a million different types of trust. A living trust is the name we give to a trust created in life, usually for the purpose of substituting for a will, and it has other benefits that we're going to talk about. Think of a living trust as a box, and we're going to label that box the living trust, or in this case of our example, the John and Jane Jones Living Trust. And the purpose of the box is to hold title to your assets. So instead of the assets being in John's name or Jane's name or both of their names, we're going to retitle the assets to the trust. So right now, they own title as either individually, joint tenancy, tenants in common. This is simply another way. We're going to title the assets into a living trust. And so literally you take all those things that we were talking about were the estate and you put them in the box. They become part of the living trust. There are three positions of any trust, and this is true with a living trust as well. There's a settlor, the trustees, and the beneficiaries. The settlors are the people who create the trust. Some people call them grantors, some people call them trustors. I think the simplest term is settlor, so that's what I use. So the settlor is the people who currently own the assets and are going to put them into the trust. So our circumstance with a living trust is John and Jane Jones are the settlors. They own the assets, they're going to put them in the trust. A trustee is the person who has the right to manage the assets in the trust. They can usually do everything with the assets that the owner can do with the assets. We want to give them a lot of authority and a lot of flexibility. So they can buy, sell, trade, loan, exchange, mortgage. They can do everything with the assets, but they don't get to use the assets. They're not for the trustee, they're for the third role, the beneficiary. They're the people, this is what you want to be as the beneficiary of a trust. They're the people who spend the money and use the assets in a living trust. If you hear someone described as a trust baby or a trust fund baby, they're the beneficiary. That's the good position to be in. Well, in a living trust, all the positions are going to be held by the same people. So you just have to remember that the settlor creates the trust, the trustees manage the trust, the beneficiaries use the trust assets. So in our circumstance, we got John and Jane Jones, and they're going to be the settlors because they own the money and they're going to put it, or the property, and they're going to put it into the trust. They are going to be the trustees because who do they trust to manage their money? Themselves. So they're going to be the trustees too. Who do they want to use the money? Who do they want to be the beneficiaries? Themselves. Now this sounds like some lawyer magic, you know, that just some sort of a gimmick. That we're creating a trust, but we're putting all these people in the same position. First of all, what difference does it make? I'll tell you that in a second, but I'll tell you that this is not something new, novel, unusual, something I'm concerned at all about that the Congress or the legislature are somehow going to outlaw. Trust law is ancient. It goes back to England's common law. Living trusts have been around for a very, very long time. There's nothing wrong with a living trust. So what does it do for you? That's what's important. At the beginning, John and Jane occupy all the same positions. They're settlors, trustees, beneficiaries, meaning that although the assets are titled in the name of the trust, if they need the money, they get it. If they want to sell the property, they sell it. It doesn't sound like it's changed a whole lot. And in a way, it hasn't. During their lives, it's really business as usual after the trust has been created. They are still in control. They can amend or revoke the trust. We make the trust revocable. So they can change the terms. They can change what's going to happen. It doesn't save or cost them any money on property tax. They don't lose their homestead exemption. It doesn't change their income tax. They don't file a different tax form. It is for tax purposes what's called a disregarded entity, meaning that the income or capital gains from the transactions involving the trust just pour into John and Jane's 1040 tax return. So it doesn't change that. So it's a whole bunch of not change. You haven't really heard why would you want to do it. Okay, you're avoiding probate. That's right. During your life, it's a standby device. Okay, in a way, it's like doing probate in advance. Where we talked about the major role of probate was to transfer the assets on death, and you might have to do that twice. In a living trust, you transfer the assets once, and and that's what we call a funded living trust. A fully funded living trust is you've taken all of your assets and you've retitled all of your assets into the trust. And if you're trying to avoid probate, you need a fully funded living trust. And so all of this property goes into the trust, including IRAs and life insurance policies may be payable to the trust as opposed to paying to individuals. It depends on the circumstances. But you might even need to change beneficiaries on those, quote, non-probate assets. So in this scenario, if you've funded your living trust, so all the assets are in the box, and John dies, do you need to retitle those assets again? No. Do you need to go through probate? No. Well, that's good, but I've told you that probate in Texas is terrible. It's not terrible. It's not terribly expensive. This is not enough of a reason for me to recommend someone doing a living trust. Again, if you're out in California, all the lawyers recommend that everybody do a living trust. In Texas, I'll be honest with you, dealing with a living trust is a certain level of a hassle. I need more reasons than that to recommend a living trust, and I can only determine that by an extensive interview with you one-on-one. So it has a distinct advantage, but all the other advantages that we're going to talk about that we can do in a living trust, we can do in a will as well. But a will, we're going to go through probate.
I have a question.
Absolutely.
Can a living trust be outdated?
Oh, everything can get outdated. The worst thing with a living trust to make it outdated is that your trustees are no good anymore. They're unable to serve, and you don't have a successor trustee, and if you don't have an adequate provision for how you're going to appoint a successor trustee, you have to go to court to appoint a successor trustee. There is a principle of law that no trust fails for want of a trustee. The trust doesn't fail, but we have to have a court action requiring us to serve in a legally enforceable way everybody who's entitled to notice before we can change the trustee. That's what's really a problem with the trust. So John's estate doesn't go into probate when he dies. There is no need to change the titles. So you're saying, why do this? And well, we're going to get back to that. Give me a second. We're going to look at the last will and testament alternative and then come back and see the problems that both the living trust and the last will, when well drafted, can solve. So what is a will? It's the document you file with the court. It has to be the last will. You never know it's the last will until you've actually died. And then we follow with the court, appoint the executor for the person to be responsible for paying the creditors and getting the property to the beneficiaries. So it's the legal document used to distribute your property. Now, to avoid the expenses and problems we were talking about that can encounter an estate, you need a will that's properly drafted from a technical perspective, that you have good executors or trustees. There can be trustees in a will. There almost always are in the wills we draft. You have proper powers given to those people. You waive bond, you waive inventory if possible, and you don't have to worry about the witnesses still being around because you've done something called a self-proving affidavit, so that the will in effect proves itself, so the probate process is relatively easy. So does it achieve the client's objectives is the other test. It's properly drafted if it does what you want. When we draft a will and give it to the client, we tell them the will is designed to be durable, meaning it's designed to last through a lot of different contingencies. But we tell them to review it at least every 5 years, or in the case of a major life event. Let me tell you a big major life event. Get divorced and remarried. That's a major life event. But obviously the death of a spouse, the death of a child, those are major life events. In any of those cases, you review the will, and it can be 15 years old, and if the executors are who you want them to be and they're able to serve, it still has the correct provisions in it. It was well drafted in the first place. It still works. There's no fuse on a will, but they go bad because life has changed and the people that you wanted to serve aren't available, and maybe the scheme of what you want to do with your assets has changed. So you review it to make sure it still meets your desires. You are going to go through probate. This is the distinct difference between a living trust and a will. There is going to go through probate, but we're going to have drafted the will to avoid all of the hassles, and we're going to keep it current. One of the things that there's a flyer in your folder about is our annual maintenance plan. I'll talk about that a little bit later, but it's designed that you keep your documents current so that not only is your will good, now it continues to be good. So another part of having a good estate, instead of just a good estate plan, is that you're organized, that you've accounted for your assets. You've listed where everything is. Let me tell you, one of the most common things I see all the time is the client comes in, they want to probate mom or dad's or sister's estate, and they say, we're positive they had a life insurance policy, but we've been all through the house and we can't find it. They said, what can you do to help us find an insurance policy? And I give them the phone book and say, start calling every insurance company able to write life insurance in the state of Texas. That's the only way to find it. There is no system to do that. There is no public register of life insurance policies. You can't call the Texas Department of Insurance and say, look this up for me. You need to organize your assets and expect them to be found. And amazingly, I mean, if you have an insurance agent, or if you just written down somewhere on a pad, in case of death, call X, Y, and Z, you will save your heirs and beneficiaries a tremendous amount of problem and grief. And so many people don't do it that basically. So we want to give you tools, and we will give you tools to help make and prod you to make sure your beneficiary designations are correct, that your assets can be found, and those doubts are eliminated in your beneficiaries. A funny story, kind of funny. My dad's name is William A. Pike. His father's name was William T. Pike. My grandfather died in 1972. For a brief period of time, never during my life, he lived in Dallas, and he must have taken out a life insurance policy at some point in time when he lived in Dallas, and of course he named his wife as his beneficiary. My grandmother survived him for over 30 years, maybe 35 years. And so she could have used that money, but she didn't know about that policy. About 5 years ago, the insurance company found my father and said, well, we have a life, are you William T. Pike? He said, no, I'm William A. Pike, but I know William T. Pike, or I did know him, that was my father. And they said, well, we thought that might be the case. We have this insurance policy, and we're kind of betting that your father's not still alive because he would be 120 years old. And he said he has been deceased for quite a long time. He says, well, the face value of this policy was $1,500 and we're ready to pay it out. So they did. He split it with his 3 surviving siblings, and so they all got rich on $500. Did anybody pay them interest on that money that had sat there for 50 years? No. No one had made a claim on the insurance company. So the 2 ways I know to find an insurance policy is wait 50 years after someone dies, or go calling the phone book. So you really have to organize your assets. I've had another estate where the assets were so disorganized, I'm not sure I've had a large bill to probate an estate that didn't involve massive tax issues. And all we were doing in that case is trying to find assets. We had to search real property records in almost every county of the state. It was just, but if you don't keep the paper, you don't tell people where it is, it's really difficult. So when does a will go bad? A will does not go bad because of time, but you want to check it about every 5 years. If you are going to have a large IRA or retirement fund, you may have tax planning and that may affect your will. Obviously, if your marital status have changed, if new children have been born or deceased, now often we draft wills to be flexible, and you can have the child to be named later in the will. To my children now born and hereafter born, but that's kind of cold. It is a good idea to actually name your children in the will. So all of these are issues that may lead you to need to update a will, but a will that is well drafted and circumstances hasn't changed does not go bad because of time alone. So the summary is that a will tells who, what, when, how much is going to go through probate and divide the assets to give it to who we want, when we want it. You're going to be prepared because you're going to have lists and identify the documents and told your beneficiaries who to call. We're going to minimize cost, minimize delay, minimize or eliminate taxes by being properly drafted, and we're going to create a roadmap for your settlers and beneficiaries so they know how to do this. So that's a well-drafted will. Now, I want to spend a little time on a critical problem in our society, and that is long-term care. And we're going to talk about how we can do the maximum planning that we can do for in a revocable trust or a last will and testament to deal with long-term nursing care problems. Long-term health care costs are a huge problem in our society. It is the single largest health care expense, out-of-pocket expense for the elderly, and it's 81% of all of their long-term health care costs. And who pays for it? Who pays for it? Well, we think that there should be government programs or your health insurance pays for it, but it doesn't. Medicaid is the only federal or state program that pays for long-term care. I mean, long-term care is a broader term than nursing home, but think nursing home, okay? It can include assisted living or other types of programs. Medicaid is for the poor. And when I mean poor, I mean really poor. You really have to spend all of your assets to qualify for Medicaid. So there's an irony, the green on this roulette wheel are supposedly good things and the red are bad things. It's really kind of hard to consider heart disease and cancer good things. But on the cost spectrum of that, your medical insurance or Medicare will pay to cure your cancer and your heart disease because it's all under a physician's care. But if what you had was a stroke or Alzheimer's, and what you really need is someone to deal with the fact that you're mentally disabled and you need someone to cook for you and clean for you and take care of you, that's not health insurance. And that's unlucky. It's hard to say that green is lucky, but red is really unlucky. So what is a long-term care event? A long-term care event is when you have these activities of daily living, and that's the terminology in the law and in insurance policies, to do these 6 things on the left, and if you have one or more of those lacking, you may qualify as a long-term care event. And obviously 3 or more and you've got a serious mental impairment or probably need to be in a full-scale nursing home. But the odds are very great that all of us will have to deal with someone in our family with a long-term care event. For a couple turning 65, there's a 70% chance that one of them will need long-term care. It's kind of putting the same facts in a different way. The number, 65% of all people over 75 need long-term care. So it's not that you're married that you need long-term care. Actually, the irony of this is I recently bought long-term care insurance, which is one of the ways to plan for this. And my policy was significantly cheaper than my wife's policy. And I said, well, what if I just buy my policy instead of her policy? They said, well, we don't sell it that way. Because this is the reality. A, the guy dies. B, when he's sick, the spouse takes care of him. When the wife gets sick, either the man's not around to take care of him or he says, let's put her in a home. So that is why predominantly females dominate assisted care facilities for those circumstances. So here's an example of the average length of stay, and it usually varies by the type of you tend to graduate from one level of care to the next. If you put that in terms of cost using a fairly reasonable, not exaggerated cost of what these services could cost, you can see in about a 5-year time period you can blow through $300,000. For some people, the only planning they have is they're going to sell their home to pay for the long-term care event. So we want to do the maximum amount so that you're not one of the 500,000 families a year that become destitute due to long-term care expenses. Well, how do we be proactive in how we plan? It is an insurable event. There is long-term care insurance, and it's something I encourage you to look at, and it is not inexpensive, and it depends which age you are, whether that is an appropriate way to finance this. But you're going to have to look at assets of your own, because you're not going to look to any of these government programs to pay for it. I'm going to talk about the exception with VA in a second. So to repeat, Medicare does not pay for it. The VA does not pay for it. Private health insurance does not pay for it. This is what pays for it, your own assets. You got to find your own assets to pay for it. So if you got to start liquidating the assets to pay for this, you want to minimize the assets that are subject to being met by the Medicaid qualifications. So Medicaid is an asset test, minimum income, and almost no assets. Now, the home is an exception. You can have a home and it not be one of the countable assets. So what are countable assets? They are assets that are available to you to pay your medical expenses, okay? So it sounds like if you got any assets at all, you can't qualify for Medicaid. Well, that's true. And you can't give away, there is a way to do this, but it's not recommended, to give away your assets and qualify yourself. But that doesn't mean assets that you receive should be in the countable category. We want, through planning, to make the assets that you give to somebody or that you receive be non-countable, that they don't count in this qualification at all. Put it in another context. You have John and Jane, where we can structure it so that Jane's, when she receives John's assets, that those assets are not countable. She will have to spend her assets for her own care, but not John's assets. Maybe we can still pass John's assets on to Susan and Timmy, or maybe we can use them to supplement Jane's life. The exception of a government program, and look how limited this is, VA Aid and Attendance. It's a great program, but you had to be not just a veteran, you had to serve at least 90 days on active duty during a time of war. Now, I don't know if we are just perpetually in a time of war now. I don't know if that counts, but it seems like we're perpetually in a time of war. But that's not the age group that we're dealing with now. We're dealing with Korean War veterans and maybe VA veterans at this point. And you meet all these other requirements. Does it then pay the full cost of your long-term care? No. The benefit right now in Texas is about $1,600 a month, which I would say is a lot better than a kick in the pants, but it does not pay for the care. And that's the only benefit other than Medicaid. So we prepare for long-term costs by being proactive, and either through a will or a revocable living trust, we leave the assets to our family in a way that is not countable. okay? So that it's a divide and conquer. Some of the assets are going to be sacrificed, some of the assets are going to be saved. And if possible, you insure for the long-term care need. We do this planning through trust that are trust provisions in the living trust or a trust embedded into the will. Get a little lawyer lingo here. When we have a trust embedded in a will, we call it a testamentary trust. Last will and testament. It's a testamentary trust, meaning a trust created by the will. In other words, it's only created when the will is probated and the circumstances require. So it's not a living trust. It's not created and funding now. But instead of leaving the assets to our spouse or to our children in an unfettered way, they just receive the assets, we leave that in a trust where they may or may not be the trustees, but they're the beneficiaries. And we've restricted the use of those assets so that they are not countable for Medicaid purposes. Okay? And what are the variety of benefits of doing it this way? Let me deal with one. Remember a picture of John and Jane? Jane was really attractive. Okay? Well, Jane had dated a boy in high school before John elbowed him out of the way, and his name was Jack. Jack had never been happy with the fact that his relationship with Jane ended. John dies, guess what happens? Jack's back. Jack's back. And he starts wooing, isn't that an old-fashioned term? He starts wooing Jane, and they get married, okay? You remember the simple will that they did? John left everything to Jane. Jane gets remarried. Jack says, you know what we need to do? We need to get new wills. They go to the same attorney who says, Will Schmill, yeah, I can do that. Everything to the spouse and then to the children. Then Jane dies. Where does her property go? Jack. To Jack. Where does John's property go? Jack. To Jack. John is doing cartwheels in his grave if, can you believe his arch enemy is getting his property? When Jack dies, where does John and Jane's property go? Yeah. Odds are to his children. So let me tell you what is nuclear explosion in an estate, and this happens all the time. Let John and Susan's children see their parents' property go to Jack's kids, and they will do almost anything to try to pull that estate plan apart. Will they succeed? No. Will they make an attorney wealthy? Yes. But the anger boils over any rationality. They may not be able to do anything about it. It is not easy to contest a will, but you can waste a lot of money doing it. So that's one example. Second example is what we were just talking about. The surviving spouse has a long-term care event, and they need to use their assets to then qualify for Medicaid. But the assets they've inherited have been restricted, and those assets are preserved. Third example, these provisions we're talking about also deal with the situation of Bruno. Okay? We're going to leave Susan's assets in a trust so that they're titled differently and cannot be commingled with their other marital property. So in case of divorce or other circumstances, there is no dispute that these are her assets and they're her separate property. And they're not going to be lost in a divorce, or you're not going to see them fought over in her estate. Finally, you get a person like Timmy, okay? And you want to restrict his assets and possibly appoint another trustee so that he can't waste the assets. You'll have almost always spendthrift provisions in a trust like that. So he can't go and buy himself a Maserati and say, give the bill to my trustee. Well, he can buy the Maserati and they can send the trustee the bill, and the trustee can say, I'm not paying for it. No, he cannot bind his trustee to spend the money. And that's a basic spendthrift provision. So even when we trust the people that we're going to leave money to, when we trust Susan and we trust Jane, there are substantial advantages to having not a simple will that just transfers the property, but keeps it restricted in trust to give those survivors maximum flexibility with their assets. And in most of the circumstances we've been talking about, these testamentary trust or provisions in the living trust, the trustee, the person who is controlling the property, is the person for whom the property is benefiting. We don't have to have a separate trustee. We don't have to go to a bank. We don't have to appoint an accountant or a lawyer to handle it. They are their own trustee.
Can a trustee, like Tim, when you were talking about, and if he was one that was gonna be a spendthrift or spend too much money, can he be put on an allowance to where the trustee can give him so much money back?
Sure.
In smaller amounts?
Sure.
Because he might spend it all at
Right.
one time.
Absolutely.
Okay.
Absolutely. We usually create a trust that's called it's a discretionary trust. We say that the trustee can decide how much, if any, he gets, so that his creditors can't sue and compel the trust to turn over the money to him. Okay?
And are there things that the trustee that is also the beneficiary in your case can do that can bust that trust? In other words, things that happen that could cause it to come back in and be...
I'm very concerned of someone who's like Timmy being their own trustee. That's, generally speaking, if the trustee can get to the money for their own benefit, then their creditors can get to the money. So you need some separation. You can't, for example, this would be great, but you can't do this. You can't throw all your money in a trust and now your creditors can't get them. It's your money. It's like while it's a living trust and you have full control over it, you have full control over it so your creditors can get it too.
I'm thinking in terms of the medical, the long-term care issue.
Long-term care, the trust is protected, and probably at that point what we advise is for the trustee to resign so that you then have a third-party trustee who has the right and duty to restrict those assets. So let's look how these plans work in both the will model and a trust model. It's the same couple, John and Jane. They have $700,000. It's a community property. The assets were titled properly. John dies, but instead of leaving the property to Jane outright, his property, his half, is going to go into a trust, a family trust, for the benefit of Jane for the rest of her life. Now, Jane's property over here is still the way it is. She still has control of her property. It's not in a trust. And when Jane dies, that family trust, in other words, John's property, is going to go to Timmy and Susan. It's not going to go to Jane's new beau, Jack. It's not going to go to Jack's family, because the family trust that is set up when John dies is going to control the rules on John's property until that property is finally and fully distributed out of the trust. So at this point, you may continue trust for Timmy and Susan, and you may not, depending on the circumstances. Essentially works the same way in a living trust model, but we don't have to retitle the assets. So if John dies first, what happens? The assets still stay in trust. They are still in trust. Jane will probably be the sole trustee at that point. But we are going to split the assets into trust in half. So there's a John half and a Jane half. Jane is going to have full revocable control over her part. She can take it out, she can spend it. John's half is locked down. She can use it, but she can't give it away. She can't change John's estate plan after he dies. She can't give his property to Jack or somebody else. So that the property passes on to Timmy and Susan automatically on the second to die. So, looking this another way, if John and Jane, in either a living trust or last will model, the survivor is going to have the benefit of the property. They're going to have the benefit of the property one way or the other, but we're going to control and restrict those assets for the maximum benefit possible and they're going to go to the children. There's not going to be any diversion of the plan. So in the will model, when Jane passes away, we are going to probate her estate in a will model, but not in a trust model. But in both circumstances, we have the option, and probably going to recommend, that there be a trust for the benefit of, that's the FBO, for the benefit of Susan or Timmy, and it's done in an asset protection way so that they have the maximum control over their assets to protect them from creditors, to make them non-countable for Medicaid purposes, and to avoid them from being part accidentally or by coercion into a marital estate. They stay distinctly separate property. So the point to remember is the asset protection provisions can be done in either model. There are non-tax reasons for having these assets in place. This is not predominantly to avoid estate taxation. It's predominantly to make sure that the assets are protected from a variety of different risks. The advantages of estate planning are to guarantee that your assets go where you want, when you want, handled by the person you want. You're going to avoid guardianship. You're going to avoid expensive probate. You're going to minimize death taxes, and you're going to protect all the assets that you can from nursing home and long-term care expenses. So our goal, and we're almost there, was a properly planned estate. Let me talk about how the whole package fits together. If you have a living trust, there are two other documents you need. An advance directive for health care, which is a little bit of shorthand because we're really talking about three documents in one. It's a medical power of attorney, an advance directive for health care, and a HIPAA authorization. Let's just call it an advance directive. And a financial power of attorney. Under the will, we're going to have the will and these additional advance directives and financial power of attorneys. So we got to put all of these pieces together. So let's talk about what is the purpose of a financial power of attorney. Purpose of a financial power of attorney is disability planning. It is the document when you're using a will that keeps you from having guardianship. And it works well in most cases, and it's a simple and inexpensive document. You grant to someone you trust the ability to handle your assets without going to court and saying, "Mother, may I?" Okay? So that's what a financial power of attorney does. So it is a very mandatory part of any plan. So with a living trust, the living trust is designed to handle those situations anyway, but it's relatively easy to draft a power of attorney, and we do it as a backup because we kind of know that there's a pretty big chance that our client's going to walk out of the office and buy an asset and not put it into the living trust. So we want to cover that too. And it's just too big of a risk. We see it too often. Okay? So it is a precaution. A financial power of attorney is a precaution when using a funded living trust. So even though the trust has all of these provisions to handle guardianship and avoid that, we want to have it as a backup. Now, with a will, a financial power of attorney really is mandatory because there is no other document that's dealing with financial disability than the financial power of attorney. So it should avoid public proceedings. Now, it's a little bit beyond our discussion at this point, but one of the big questions I have when I meet with someone is your circumstances such that it's highly likely that if you're disabled, the estate fight's going to break out in advance? In that case, there's a strong preference for me to recommend a living trust model. If not, it's a non-factor. So it's a question I ask when we have a direct one-on-one consultation. What is the advance directive for a health care? It is what some people call a living will. The state of Texas allows us in two defined circumstances when there is a irreversible condition or a terminal condition for us to direct in advance that if we're in that circumstance and we can't speak for ourselves, we have made a decision what kind of health care we want. And the choices are basically give me everything medical science has available or let me die naturally. Okay, and you're given those choices. And you appoint the person who's going to make the medical care decisions for you when you're not able to. And that will protect your assets from unnecessary medical care expenses. Now, in the course of my legal career, we have gone from having problems with doctors who were very nervous to withhold care a long time ago, 30 or 40 years ago, to where today the whole medical community is conditioned to withhold care when they don't see it being helpful. And especially hospital administrators are like, can we get that person out of ICU that's on Medicaid? Can we get that person out of ICU? So they don't have a problem with withholding care when it is medically appropriate. Who has a problem with it? More than anybody else, the kid that is totally estranged from their parents and hadn't seen them in 20 years and shows up on the deathbed full of grief and remorse, and they say, we can't disconnect. If you have a medical power of attorney, you wouldn't name that kid, right, to handle your affairs, okay? And the other person is going to get to make the decision. You don't have a medical power of attorney, despite the fact that every time I do an advanced care directive, and I never make a choice for a client, I put it on the table, I show them both choices, they initial the one they want. All of my clients have always made the same choice. We don't want to be hooked up to a bunch of tubes. You know what the law presumes if you don't speak in advance? That you want to be hooked up to a lot of tubes. It makes a lot of sense. Sometimes the law is an ass. So we're going to put this all together for you, and it's not just about looking neat. I mean, we're going to put it in a binder, and this doesn't make it more legal. You know why we put it in a colorful binder? You can find it. You wouldn't believe how many. We've been going all through the house, and we know there's a will here somewhere where we can't find it. We're also going to give you clear explanation of the documents. If we need to redesignate beneficiaries or non-probated assets, we're going to help you do that and give you really good instructions. Give you a variety of tools on how to organize your assets, to have a location list. We recommend a service called Everplan. It's not something that we make any money off of, but is one way to organize your assets. Give instructions for your executors and trustees, and this is really helpful for people who are visual learners. We create a flow chart of your estate so you can see how one thing relates to another. So that's what we're aiming for you. There's a sheet in your packet that's a pink sheet, and we're going to talk about the cost of the services in just a second. The first thing you want to do is choose an attorney. Okay, so obviously the best way to choose an attorney is find who is absolutely the cheapest and hire them. Okay, and I'm glad when people actually laugh at that part. Okay, yeah, or yeah, the guy you saw on the billboard, or the one you talked at the cocktail party who said, "I'm an expert on everything." Okay, so you definitely want to understand and make sure you're getting a fair price for the services, that you're getting good quality service. We think we do that, and we are very concerned with your whole financial picture. We don't want you just to have a good estate planning document package. We want you to have a successful estate. We do that in a variety of ways. One of it is to have an annual maintenance plan, and we'll talk about that in a second. So here are the options. If you're unmarried, divorced, widowed, you're single, either option 1 or option 2, the cost for all the documents is $1,750. Okay, it's the same. We're going to have a deep discussion on a consultation which is the best option for you. There's no cookie cutter, but there's no financial incentive for us to sell you one thing versus the other. If we have to retitle property, preparing and filing the deed is $225 each. Usually that's only required with the living trust option. For a couple, the costs are not double. It's $32.90, and again, that is exactly the same under both options, and again, deeds cost $225. And those are the documents that you receive under both scenarios. Now, do we have customized estate planning? Most of our clients fall into the options that I've given you. Some people come in and they need minor revisions to the documents they already have. They have wills that are good, but they need powers of attorneys that are updated, or they have a ridiculously simple situation. And some people have really simple situations, and we customize the plan for you. So, and then some people have ridiculously complex situations. If you own 52 different mineral interests in 10 properties in 5 states, it's going to cost more than $32.90, okay? But you kind of already know that already. So really there is no bait and switch. Most of our clients fall into the circumstances that I just gave you. And we have an annual maintenance program. It is free for the first year. Actually, for a limited time, it's going to be free for the first 2 years if you purchase the full plans that we just talked about. And those are the costs thereafter. What's the purpose of this? The purpose is so that your significant investment in these documents does not go bad over time. That we commit to you under this plan that we will contact you once a year and tell you whether you need to update your documents. I know, for example, that our legislature has just substantially modified the medical and financial power of attorney laws. I haven't even read the whole bill yet, but I know we're going to be modifying our forms, and every power of attorney that we did last year we're going to redo. And under an annual maintenance program, there will be no fee for that, other than the cost of the plan, and I'm going to give that to you for 2 years. Because, again, I don't want you to say, well, I did these documents, but now they're bad, and they really don't do me any good anymore. So we want you to sign up for a free consultation. Some of you have already done that. If at all possible, we'd like to schedule that in the next 2 to 3 weeks. Why? Because my first question to you will be, what did I say to you during this seminar that made you think you needed to do something with your estate plan? What caused you concern? What caused you heartache? What of the things I said is your situation? So we'll drill into your particular circumstances, because there is no cookie cutter estate plan in our office. If you're married, we want to meet with both husband and wife. I cannot have, and it's usually the man, okay, the man come in and say, this is what me and the little woman want. The little woman has to hire me too, okay? And she has to tell me what she wants, okay? I can represent one or the other. That happens in rare cases. But if I'm going to represent both, I have to talk to both of them and be hired by both people. Every once in a while I have someone who comes in and wants to talk about somebody else's problems. I'm happy to consult with you at an hourly rate about someone else's problems, but it's not getting to your estate plan. I cannot, again, do mom's estate plan because you tell me this is what mom wants. Mom has to tell me what mom wants in a private attorney-client way. At the end of the consultation, we're going to be able to drill down and give you an exact price of what we are recommending. I think it's going to be the prices I've already showed you, but it may be customized differently. And at that point, we'll say you want to do it or you not do it. If the answer is no, we part friends. There is no pressure in this process. So as until we have finished the full consultation process and have told you exactly what we're going to do and exactly what it's going to cost, that we ask you to make any commitment financially whatsoever. So that is our seminar. Thanks for coming. Are there any questions, Elle?
I have a question. Listening to you, I am just amazed to discover that it sounds like there is a way to, let me use the word hide, or put your assets elsewhere so you qualify for Medicaid. And how is that different from Medicare?
Well, Medicare you get because you're over 65.
Right. So you're talking about people under 65 that need long-term care.
No, it's because Medicare doesn't pay for long-term care.
But Medicaid does.
Medicaid does.
Only if your assets are small.
Correct.
So you find a way to put them elsewhere so you look like you have small.
It's generally that the assets that you receive that you don't get in the way, or that the assets you pass on, that you don't disqualify the next person. You know, a very common example is you have a child that has a mental disability. They're never going to have any income. They've qualified for SSI benefits and Medicaid from the time that they're 18. Okay, you don't want to disqualify them by leaving them money. Okay, right. So, but you can't, it's very difficult and usually not within the scope of good planning to take your own assets and put them in a way that qualify you for Medicaid, because you're going to have lost control of those assets. Your own assets. Very difficult to do with your own assets. Now, the distinction between Medicare and Medicaid on long-term planning is, has anybody had a friend or relative go into rehab okay, after they've had a major event like a stroke and they go into rehab. And Janet, when they went into rehab, did it kind of look like a nursing home? It looked exactly like a nursing home. You know why? It was a nursing home. But there's this fiction that for 90 days, Medicare, am I saying it right? Medicare will pay for rehab. On the 91st day, oh, that's long-term care. We don't pay for that. Boom.
And they kick you out.
Oh, they kick you out, or they just start billing you. And so, if it's really not rehab, they really need long-term care. They're not going to get better. They can't get taken care of at home. All the facilities just glad to have you there as a private pay client at $5,500 a month or whatever. Nursing home costs are like cars. You want to drive a Urus or a Maserati, you can almost find anything.
It's ridiculous. It's like
There's
expand of how much it costs.
one of the flyers out there is for, we got flyers out there for all sorts of people that deal with this. People are experts at taking care of people at home. One who's senior care living specialist that's really good at helping people find facilities. And CNC is an expert in providing professional care, sometimes to advise people on what they really need before they make a decision whether they move somewhere. Senior living specialist is run by a young man who I think is just terrific. And what he does is interviews people and says, I can determine what kind of care you need, and I know 10 places, and here's the laundry list. And sometimes, well, let me tell you, not sometimes, the most expensive places may look fancy, but are not necessarily the best. And someone who's knowledgeable in the industry can just be a tremendous help if you have to make that decision for a family member. There's just all sorts of resources out there, and I can share those with you if any of you need them at any time. Well, I appreciate your time. Gary, you have... Thanks.